Well, thank you, David, and thank you for having me here this evening to talk with you all. First off, I'm a personal injury attorney, and I have been for the 13 years of my career. Until recently, I worked with one of the larger personal injury groups in the area, and I was a supervising attorney. And so I oversaw, hired, and trained all of the attorneys in our group. I've had the good fortune of having some really wonderful clients and some really wonderful experience. I spent the first 8 years of my practice handling litigated cases exclusively, which meant that I got to be in the courtroom far more than most of my colleagues. And believe it or not, that was a really fun place for me to be in. It's one of the places where I love being. But I don't want to talk a ton about myself. You're welcome to look at my website, palumboinjurylaw.com. I love talking about my clients. Take a look at my results page and you'll see quite a few examples of people that I've been able to help over the years. So with all of that, I'll go ahead and get started on our conversation today. I've been asked to come here today to talk with you about the motivations to treat personal injury patients, even when the account balance will have to be held until settlement. So there's different terms that we use in our industry for that. Some people call these lien accounts, third-party billing, treating on an IOU basis, or taking patients on a pay at the time of settlement. I'm probably going to use all of those terms. In the 13 years that I've been practicing law, I've had a chance to meet some really fantastic doctors. And one of the most common things that I'm asked is, how do I build my personal injury practice? And what I say is simple. I say treat injury patients who need the medical care for as long as they need the medical care. In other words, kick the insurance industry out of this decision. This is a decision that's best made between you with your clinical experience and your hands-on experience with the patient and the patient who's suffering the health issues and knows what their health was like before this type of injury and has the motivation to get better. And that's it's a pretty aggressive goal to have for a doctor, to just treat people regardless of whether you're certain you're going to get paid. And I'm not suggesting that you do this without a lot of thought. What I'm hoping to give you is some tools to establish practices and protocols in your clinic so that you feel comfortable and confident that if you take patients on this pay at the time of settlement basis, that you will in fact be paid at the time of settlement. So just to lay out a little bit of a roadmap for you tonight, I'm going to be talking with you for about 30 to 35 minutes, and I'm going to cover 4 main topics. The first thing I'm going to just talk about is we'll work on dissecting the motivations to treat patients on an IOU basis. In other words, why in the world would you want to do this? The second thing we'll discuss is what things you're going to want to consider to determine if IOU accounts are right for your clinic. The third thing we'll do is I'll give you some case-by-case analysis factors that you're going to want to go through for each potential PI patient that you're treating on an IOU basis. In other words, even if your clinic adopts a policy in general that you're going to treat patients without insurance, injury patients who don't have insurance, you're going to still want to go through a case-by-case analysis because there are going to be some PI patients who are not good candidates for carrying a balance like this. And then the final thing we're going to talk about is I'm going to review with you 2 different tools that you can use to secure your balances, and I'll discuss how you can maximize your recovery on those balances. David, I'm trying to move my page here and I'm like, oh, here we go. Sorry guys, bear with me. Okay. First, let's talk about the motivations to treat patients even when you're going to have to wait for payment until settlement. An obvious question is it economically feasible? In other words, are you going to go out of business if you try to do this? And to review that question, I took a look at some data and I saw that the American Chiropractic Association did a study that surveyed clinics to determine where the average clinic receives its revenue stream. And what you can see from this is that if you're the average clinic, then 40% of your revenue comes from cash payers or from PIP. And that's great because usually the percent on return is going to be about 100%. that's assuming that your cash payers aren't getting a big discount. What it also means is that if average clinic is going to have 60% of its patient load that receives a huge discount off of the customary price of care. Now, one of the common frustrations that I hear from doctors in terms of whether they would be willing to treat on an IOU basis is they're fearful that at the end of the case they're going to have to take a large reduction. I will tell you that if you're working with an experienced attorney, reductions should not be the norm. They should be rare. You should be paid in full on most cases. There will be some cases that you run into where there's going to have to be a reduction. And if there has to be a reduction, the attorney should be willing to share in the percentage of reduction that the clinic is going to be asked to take. In other words, if you receive a call from me asking for a reduction, I'm only going to do that if I too am willing to reduce by the same amount. So I'm not going to call and say, listen, doctor, I'd like you to cut your bill by 20%. I'm going to call and say, if you're willing to cut by 20%, then I am too. If you don't want to do that, let's go ahead and try the case and see where we end up. The second thing that I hear from doctors is that they're afraid that their PI rate of return is going to be diminished far beyond what they could be getting as a rate of return if they spent their time elsewise. But what I would suggest is that if you do these cases on an IOU basis, at the end of the year start doing the math and take a look, because my guess is that your rate of return on the PI cases, even with the few reductions you're going to have to take, my guess is that your rate of return on the PI cases is still going to exceed that of private health insurance. I'd almost guarantee that it will exceed that of the L&I cases and the Medicaid and prepaid cases. At the end of the day, everybody has the goal of being able to work less and earn more. For you guys as doctors, that goal is a great goal because it allows you to give optimal patient care. In other words, if you're billing under L&I and you're having to see 2 patients to get the fee that you would normally get from 1 patient, you're going to end up having hurried visits. You're going to have less attention to detail as you try to rush through all of those patients. And it's also going to create less balance in your own life, diminishing the ability or the level of care you might be able to give to your patients. So what clinic would benefit from treating patients, injury patients, on an IOU basis? Obviously, nobody is going to suggest to anybody that you should turn away cash-paying patients. So in other words, if your schedule is packed with patients who are coming in and paying cash, then it would not make any sense for you to even consider taking patients on an IOU basis. Most of the doctors I talk with, though, have gaps in their schedule from time to time. And my suggestion would be that if you have regular gaps in your schedule, you're going to have to decide how you want to spend your time during that gap. You could spend that time doing nothing and hoping that patients just kind of magically appear. You could spend that time doing some online marketing. Now that we can do marketing online, you could go online and update your blog or something like that, and that would be a productive way. Or you can spend that time treating members of your community who are seriously injured, who seriously need the treatment, but who won't be able to pay you that month or maybe even the next month, but who will be able to build a future revenue stream for you. Sorry guys, I skipped a slide here. When we talk with our financial advisors, we're almost always told that we should not put all of our eggs in one basket. They also tell us you should balance your short-term gains and your long-term gains, and you should balance your low and high-risk investments. And so this graph that I have for you is more illustrative than it is instructional. I'm not telling you that you should carry 1/3 of your revenue on an IOU basis. I will tell you that as lawyers, if this was my pie chart, you would see that it was all one color, solid, because 100% of my cases are paid at the time of settlement. In other words, I'm not here to tell you that this business model works in theory. I'm here to tell you that PI attorneys do this. This is what we do. And in my practice, I'm solely PI, so every single case on my shelf, I'm going to do the work and then get paid on the case once I've completed my work. Part of that is why I have this theory that those who wait should be rewarded. In other words, If I'm willing to work on a client's case for a year or two without any payment until I'm done with the case, then at that point when the client comes to me wanting steep reductions in the fee, I'm likely going to say, I'm sorry, I've waited all this time, I've done all this work, I haven't seen a penny until today, and that's why I'm going to take a full fee. I believe the same is true with the doctors, and I'm often educating my clients at the end of the settlement when they see the balances due to the clinics, and they say, well, geez, you know, $10,000 seems like a lot for my chiropractor. I didn't realize my bill had become so high. That's the point when I think a good attorney goes back and says, look, you know, not a lot of clinics will treat patients on an IOU basis, and there are so many injury victims who cannot find anybody to treat them, and so the few clinics who are willing to take that risk really do deserve payment at full when the settlement comes, and that's a discussion that I have with clients time and time again. You know, as a side note, that's one thing that you're going to want to do if you start working on PI cases, is you're going to want to get to know the lawyers that you refer to regularly. And you'll want to get to know the ones that are referring patients to you as well. Because I really do think that sometimes that lawyer's standpoint is going to remain the same. In other words, it's kind of hard to change hard or long-held beliefs. And I think that if you get to know them and what their theories are, you'll start understanding how they view the group of people involved in a claim. From my perspective, I think we're all a team. I think that my only obligation, my number one obligation, is to do good work for my client. I think that part of the way that I do good work for a client is I work with clinics who have strong providers and good doctors in them, and then I treat those people well at the end of the case, and I think that's the best way to practice law and to give my clients the best service that I can. One of the biggest concerns that doctors have when they're carrying balances on accounts is, how long is this going to take? In all of my practice, I've never once had a client come to me at the end of the case and say, you know what, that was great work, but it just happened too fast. The opposite is true. Unfortunately, our civil justice system is overburdened with cases. We take a back seat to the criminal cases because they have rights to speedy trial. And so this is a process that inherently can take some time. If you have an experienced attorney on board, they can make sure that the case moves forward as efficiently as possible. In my practice, about 2/3 of my cases settle without a lawsuit being filed. And those cases usually settle within about 5 months after the treatment ends. You're going to want to look at the date that the treatment ends as a relevant marker for calculating your timeline. A lot of doctors will say, well, geez, this collision happened clear back in 2013. But the date of the collision isn't a very good predictor of when you'll get your payment on a case, because some people treat for 3 weeks and some people treat for 3 years. So the better predictor of when the payout will occur is when the treatment ends. Once the treatment ends, then the lawyers are going to order up the records, create a demand letter to send out to the adjuster. The adjuster will spend a month reviewing it, and then negotiations will begin. So a good estimate on the majority of the cases is going to be that if you have an attorney pushing the cases in a diligent manner, then those should settle within about 5 months after the treatment ends. About 1/3 of my cases end up in lawsuit. Those cases are going to take longer, and many of them settle shortly after the lawsuit is filed. For the ones that go all the way through to mandatory arbitration, you're going to be looking at about another 6 months after the lawsuit is filed. And that's basically the general time frame that you're going to have when you're working with most attorneys. I want to say in my practice, I've always been really big on measuring a case lifespan. In other words, not only do I track my statute of limitations and track my patient or my client statuses, but also on a firm-wide basis, on a weekly basis, I'm looking at case lifespans. Because if I have an old case sitting in my office, the older that case gets, the more unhappy my client is, the more unhappy the doctors are, the more unhappy I am as a business owner because I want my revenue stream moving as well. And the other thing is that cases that are left to sit too long after the patient has hit their plateau, those cases don't age well. In other words, time is usually not on the plaintiff's side in letting a case sit and sit and sit. And so if you're working with a firm, or if you've repeatedly come into contact with a firm that seems to be very, very slow in getting their cases moving, that's not generally going to be in your patient's best interest. So in some of this topic of why clinics are motivated to treat injury patients, I'll tell you, I think first and foremost, the motivation comes from a desire to give good service to people. It's a community service. I think it's really difficult as a doctor when somebody comes to you in obvious pain to turn them away and say, I'm sorry, if you don't have money, I can't help you. And so I think first and foremost, those clinics who are willing to treat on an IOU basis are offering a really wonderful community service. And I think generally that community service ends up paying you back twofold, if not more, because I just think it's kind of the way karma works out. The other motivation is it's an effective use of your free time. If you're not doing anything else on your calendar, spend your time in a way that's going to build long-term revenue streams. And then the final thing we haven't talked a lot about is that when you help somebody in a really desperate position, an injury victim who has no money to pay for the treatment they need, when you help a person out of a really tough situation, they usually are your most loyal customer. So they're usually going to come back to you as a maintenance patient. Hopefully they'll learn their lesson by not having purchased PIP the first time. They'll purchase PIP, and then if they get involved in another collision, they'll be right back in your office. I was looking at some statistics before I did put this seminar together, and I saw that on average a person's going to file 3 to 4 claims in their life. And so the idea that you're not going to have a lot of the same repeat PIP clients, it's not true. You're going to see them over and over again, and in my practice I see the same injury clients over and over again as well. The next topic on our agenda is case-by-case review. In other words, every case that comes into your office that you're considering for treating on an IOU basis, you're going to want to review that to make sure that it's a good candidate for that type of account. And I've got 4 things here that you're going to want to take a look at. The first is you're going to want to make sure you have an attorney representing that patient. We never recommend, and I don't know any attorneys who recommend, that a clinic treat a patient on an IOU basis without an experienced attorney watching over the claim. There's a couple of things that can happen. You can have a client miss the statute of limitations. 3 years seems like a long time, which is the Washington State statute of limitations, but it's really not that long. The other thing that can happen is your patient may think that they're settling just the property damage claim of the case, but actually be settling the injury claim. And then the third thing that can happen that I see all the time is that once you put your patient in direct communication with the adjuster to negotiate, oftentimes what we see is we'll see the adjuster really dupe your patient. And so once those negotiations begin, your patient's going to be hearing all about how chiropractic is not a good modality of care. This chiropractor bills too much. I see them on claim after claim after claim, and their bill is always outrageous. Oh my gosh, I can't believe you paid $10 for an ice pack every visit. And so it's incredible how frequently I have patients come to me after they've attempted to negotiate their own claim, and they'll come and they're just piping hot mad at their chiropractor, and I don't understand why. And then I realize that what's happened is that they bought the insurance adjuster's line of argument, hook, line, and sinker. And of course, I don't even think that the insurance adjusters always believe that stuff. They're just doing their job, and their job happens to be paying as little on these claims as they possibly can. The second case-by-case consideration you're going to want to look at is whether or not liability is clear. And as a doctor, that's a hard assessment to make. My best advice to you is to create a mechanism that puts you in touch with the lawyer right away so that you can ask the lawyer's opinion about liability. And I've got some material that's going to be available for you all. And in that material is a form. It's a sample letter of guarantee that I've created. You can save it to your computer, customize it with your clinic information, and make it part of your packet. But that letter of guarantee has an attorney section at the bottom that helps you start this conversation and get clear answers. The third case-by-case consideration is patient presentation. It doesn't happen that often, but unfortunately all of us run into that patient that we just don't like having to deal with. And chances are, if your staff doesn't enjoy having the patient in the clinic, and if you come to a point where you just kind of dread having the patient appointment, that the jury or the arbitrator or whoever it is that's making a decision with regard to money payout is going to feel the same way. And so if you have one of those really difficult patients, understand that you're going to have a higher risk if you're carrying that balance on an IOU basis. And then the final case-by-case consideration, this is another one that you really can't assess on your own. You're going to need the help of an attorney that's representing your patient. And that is determining if there's sufficient insurance to cover the debt. You do not want to run into a situation where you've got a $25,000 clinic balance and a $25,000 policy because there's not enough money to go around. You're going to have to pay the attorney a third, the client's going to want some money, and you're going to want some money. And so you will certainly be in a situation where you have to take a reduction. I tell the doctors who I work with, once you hit that $10,000 mark, you should, on a balance, if you're carrying a balance, once you hit that $10,000 mark, you should be having a real serious conversation with the attorney as to how much coverage is available and whether or not there's any issues that you should be aware of. Anything above $10,000 when you're carrying a balance, if in fact you've got a $25,000 policy, which in Washington is the minimum amount of coverage that's required by law. If you have a $25,000 policy and more than $10,000 or $12,000 in balances, you're going to have some difficulty having enough money to go around, and that's a common situation when you're going to have an attorney talking with you about a reduction. The last topic that I'm going to discuss with you tonight is how to limit clinic risks. And again, first and foremost, I think you should have a good attorney on board. That will really help you out. Once you've got that step covered, you've got two options for tools that you can use to protect your balance. The first tool, I think, is the most common tool, and that's a lien. What is a lien? A lien is simply a legally binding document that is filed by your clinic against your patient as a public record. This is what a lien looks like, and I've provided this information. I'll have this information available to you as well. And I'm not going to cover the whole thing, but I do want to go over the first 4 columns here because the terms that are used on liens are not terms that we use in everyday life. So the top one is the claimant. And in this situation, your clinic, the doctor, is the claimant. You're the one claiming money due. The second is the patient, which obviously is your patient. The third column is the tortfeasor. Tortfeasor is just a legal way of saying the person who caused harm through their negligence. So generally in an auto case, the tortfeasor is the bad driver. And then insurer is the bad driver's insurance. So on a form like this, it's not self-evident which insurance they mean. They could mean the PIP, they could mean all sorts of things, but what they're referring to here is the bad driver's insurance. Now there are some advantages and disadvantages to a lien, and the reason I want to talk with you about the advantages and disadvantages of a lien is because you do have another option or another tool to protect balances, which is the letter of guarantee. So let's start talking first with the advantages and disadvantages of the lien. One of the biggest advantages of a lien is that adjusters take them seriously. So in other words, if you file your lien properly, and if you are successful in delivering it to the adjuster, then at the time of settlement, the adjuster is going to require that the settlement check either come issued jointly to yourself and your patient, or the adjuster is going to say, let me send the clinic's balance directly to them, let me send your check directly to you. Or if there's an attorney on board, the adjuster is usually going to say, I want written verification from the clinic that you have in fact promised to pay the balance. And so that's one of the biggest advantages of having a lien, is that adjusters will usually make sure if there's a lien properly filed and they're aware of it, they will usually make sure that that lien is handled in one way or another. The second advantage of a lien is that it really is your only option, your only good option if you are brave enough to represent a patient on an IOU basis and that patient does not have an attorney. This is also true if you're representing a patient on an IOU basis and you've learned that they have terminated their attorney. Once you don't have an attorney on board to help protect your balance or to help recognize your balance, you're going to want to make sure that you have a lien filed. And then the final advantage, at least an advantage from the clinic perspective, is that liens are an online, in most counties they're online, they're a public record. So it's really fairly easy to go online and see if anybody has a lien filed against them. Now, in a perfect world, that would mean that before settling any case, an adjuster would look online to make sure that there is not any lien filed against that client. But in reality and in practice, it's very rare that I have an adjuster telling me about a lien, and it's more often that I am telling the adjuster about a lien. For one reason or another, the insurance industry just has not built into their protocol to do lien searches before they settle cases. So that's why, I stated with my first benefit that the adjusters take it seriously. That's why I stated that cautiously and said if they're aware of it, they will take it seriously. Now, there are some downfalls of a lien as well. The first downfall is the administrative burden. It takes time to learn how to file these properly, and it costs a little bit of money. You've also got the administrative burden that they're only valid for 12 months, and so you have to put some sort of tracking system in place to renew it every 12 months. Otherwise, your lien is invalid, and all that work that you've done to get it filed and served has just gone out the door. Another thing that's kind of a hassle is that these have to be notarized, and so if you don't have a notary in your clinic, and most clinics don't, then you're going to have to find another way to get this document notarized. And then finally, you've got the administrative burden that once you've been paid, you need to file a release of lien or a satisfaction of lien. And if your clinic fails to do that, then your patient is going to continue to have this public record of debt, even though the debt has been paid. The second downfall of the liens is that it does look bad on your patient's credit. So it's a public record of debt, and if your patient goes to buy a house or get a loan for a car or anything like that, then the lender is going to look unfavorably upon that. And so most patients are not very happy when their providers file liens. And then the final downfall of the lien is that despite all of this effort and time that it takes to get the thing filed, the truth is it's not bulletproof. It's still subject to the 25% lien statute. And a lot of you probably know what that is, but I am going to discuss it in length at the end of our conversation. The second option for protecting your balances is to protect them with a letter of guarantee. And I'll be honest, this is my preferred route. I think it has some advantages over a lien. A letter of guarantee is simply a written agreement between the doctor and patient promising that the patient will pay the balance in full. I've got an example here, and I've got this template available for you all as well. And this is an example of a letter of guarantee. And I know there's too much text in here, so I'm just going to highlight the three main things that a letter of guarantee can do for you. The first thing that a letter of guarantee does is it requires the attorney to pay the clinic balance directly to the clinic. So in other words, when I get a settlement check, I won't say, okay, great, I've taken the law firm's attorney fee out of this settlement check, and now here's the rest for you, client. By the way, please make sure you pay your doctor. I don't do it that way. Instead, I say, okay, I've received the settlement check, I've taken the attorney fees out of it, I've also sent a check to your doctor, and now here is your portion of the money that's left over. The second thing that a letter of guarantee does is it promises not to rescind the document. So sometimes, for one reason or another, a client isn't completely satisfied with what is left for them in settlement. And so oftentimes at that point they start revisiting the idea of whether or not they want to pay balances. And what this document says is that if I agree to pay your balance and then you treat me, I'm going to actually pay your balance. I'm not going to try to go back on that at the end of the day. And then the third thing that the letter of guarantee does is that it makes your patients aware of the fact that no matter what happens in settlement, they are still ultimately responsible for this bill. And so God forbid if a verdict comes out really poor, you may not get all of your balance out of the verdict, but you still are going to hold the client or the patient ultimately responsible. And it lets the patient know that ahead of time. Now, one of the things that I've added to my letter of guarantee, and I have not seen this on anybody else's letter of guarantee, but I've added an attorney section, and that's this section down here in yellow at the bottom of the template. And what the attorney section does is your patient says, you know, attorney, please answer these few questions for my doctor. And the first question is liability admitted or is it clear? Yes or no? If not, please explain. The second question is the at-fault coverage, do you know what amount it is? I'll tell you, in Washington, the insurers do not have to tell us what their coverage limit is, and about 50% of them refuse to do so. The other 50% will tell you every time you ask. So the problem with not knowing what coverage is, again, is if you're planning on carrying a balance over $10,000, you're going to want to be very careful to know what coverage might be available. The third question on here is, what is the underinsured motorist coverage amount? Now, this is a question that every attorney should be able to answer, because unlike the at-fault insurer, your patient's own insurance company does have an obligation to disclose limits. And so if you've got underinsured motorist coverage, it changes the available coverage for you and enhances the discussion you should be having with the attorney if your balance starts exceeding that kind of $10,000 mark. Now, people often ask, where do you put this form in your practice? Where does it work out best? And in talking with the doctors that I've worked with, most of them say that the best place to incorporate this template would be to put it with your personal injury questionnaire. So a lot of clinics will have a personal injury questionnaire, and then they'll have a patient responsibility form, and then I would put this letter of guarantee in that packet. That way, when you're sitting down with your patient, when you're going over your reported findings with them, you can have them fill out the patient financial responsibility form. You can talk with them about the treatment plan, and then I would go ahead and have the letter of guarantee signed. If this were my practice, and what I think has worked out best for the clinics that I have talked with, is do this on every case. So even if you have PIP paying on an injury claim, go ahead and have the letter of guarantee signed. And then that way, if your PIP terminates or if it exhausts, then you don't have to go back to square one and get all of your ducks in a row. Instead, you know, well, geez, as part of our protocol, every injury patient's going to have signed a letter of guarantee. If they refuse to have signed the letter of guarantee, that would have been flagged in one way or another. And so even though PIP has cut me off, I firmly believe this patient needs more care, and I'm going to go ahead and treat them. Now, as with liens, letters of guarantees have benefits and disadvantages as well. And one of the biggest benefits that I see with a letter of guarantee is the fact that this is something that you enter into with your patient. And so a lien is an action or a document filed against your patient. A letter of guarantee is an agreement that you make with your patient. And I know that sounds like a really subtle nuance, but I'll tell you that, you know, having done dispersal after dispersal with my clients, when the clients have a letter of guarantee and have had this conversation with their doctors up front, there's usually no question about paying the balance in full. When there isn't as much conversation about how this balance will be handled, then I have a lot more questions. And so the patients that go into the process with their eyes wide open, it usually just really works out to our benefit. The second advantage of a letter of guarantee is that it's free and it's easy. The third advantage, of course, is it forces that upfront discussion. And so just like every other form in your injury questionnaire packet, once you've gone over the letter of guarantee form 3 or 4 times with 3 or 4 patients, it will just become very easy and very routine for you. But from the patient perspective, that's very informative, it's very educational, and it really helps them understand that, hey, at the end of this case, I'm going to want to have my balance paid. And then the final advantage to the letter of guarantee is that it's not subject to the 25% lien statute. So if you have a letter of guarantee on a file, an attorney approaches you saying, hey, I'm going to need a steep reduction, and by the way, there's a statute in Washington called the 25% lien statute, then what you'll say is, yes, of course, I'm really aware of that statute, but in this case, I have a letter of guarantee. In other words, this patient promised to pay my bill and, in fact, instructed you to hold sufficient funds out of my settlement to pay my bill in full. And so it really takes the teeth out of that bite that some lawyers use to cut back on clinic balances. There are some disadvantages to letter of guarantees, however, and the biggest disadvantage is that they really are not a viable tool if you are the brave type of person who's treating an injury client on a letter of guarantee or on an IOU basis who does not have an attorney on board. So in other words, one of the biggest reasons or the biggest benefits of the letter of guarantee is that your patient is instructing their attorney to hold the money. If there's not an attorney to give that instruction to, then the letter of guarantee is not nearly as effective. You'll see that in the form that I have available for you, it instructs not just the attorney to hold your balance, but also the adjuster. But I will tell you that adjusters don't really understand letters of guarantee. I've worked with them on it, and I've explained it to many of them, but I think it's a process that they need to continually be educated on. And so I wouldn't recommend a letter of guarantee unless you have an attorney working on the case. And then the final downfall, at least from the clinic's perspective of the letter of guarantee, is that it's not a public record. And so in theory, if you had that really diligent adjuster searching for all liens before issuing payment, that's not going to show up with a letter of guarantee. Again, in practice, I just don't know very many adjusters who actually do lien searches. So with all of this, this brings us to the 25% lien statute that we've talked about throughout the discussion. And this is what the 25% lien statute says. It says that all liens for services rendered to any one person as a result of one accident shall not exceed 25% of the settlement. So that means if there's 10 healthcare providers and 10 liens by those healthcare providers, then that combined balance cannot be more than 25% of the settlement. And if it is more than 25% of the settlement, then the patient is only required to pay up to 25% of the settlement on those liens. Now, this is a statute that's misunderstood by a lot of people. Quite honestly, attorneys don't all understand the statute. The patients almost never understand the statute, and some of the clinics don't understand the statute. And what I found in my practice is that usually as an attorney, when I really explain this statute to my clients, they don't want to use it. And the reason is because this doesn't get your patient off the hook from paying your bill. You could still send that patient to collection. You can still aggressively pursue payment of the remainder of the bill that wasn't paid under the 25% statute. And so usually once I explain that to my clients, they'll say, well, geez, the reason I came to you was to get all of my bills paid and to get a fair settlement. And so if I still have this debt hanging over my head, then that's not really a fair settlement, and I don't want to do it. So I think that education is really important in terms of combating this 25% lien statute. What I will tell you is that even if it's not the attorney really advocating or pushing this 25% statute, there will be other people in the settlement rooms doing so. I'll give you an example. About 5 years ago, I was representing a young gal who was really badly hurt in a car crash, and she had a little over $20,000 in chiropractic care. And I knew the chiropractor. I knew he was a reputable chiropractor who really gave good care. And I didn't think that his bill should be reduced. I thought that the bad driver should have to pay for it. And so when the insurance adjuster showed up for mediation, the first thing she said was, I'm not going to mediate this case unless Mrs. Palumbo allows me to call her doctor or her client's doctor and explain how unreasonable this bill is. And I said, well, you can show yourself to the door. And by the way, you're going to pay this mediator's fee because that's ridiculous. The other thing is that sometimes it's the mediators themselves carrying the printout of this statute because a lot of times they just want the case to settle. Not all of them really care what the outcome is. They just know that if they get a reputation for mediating cases without reaching a settlement, then they won't be used as mediators anymore. And so I think it's always important for you to understand that if you're not working with a lawyer who really understands this statute and who really firmly believes that a good settlement is not one where your patient can still be held liable for additional debt, then that's going to put you at some risk. Which brings me to the final step, or the final slide on my presentation tonight, and that is, what steps do you take to get through a balance reduction request? And I want to tell you a little story. In my practice, my office is about 3 miles away from a large chiropractic clinic that has a large PI patient base. And I know the doctors over there pretty well, and one day one of them called me up and he said, "Geez, Autumn, I'm sorry, I have a question for you. It's not even a client that you represent, but I just received a check, and it's for a minuscule of my total balance, and it was accompanied by a letter that says, under the 25% statute, this is what you're entitled to." And he said, I mean, can they really do that? What's going on here? I treated this girl forever. She really needed the treatment. So I said, well, let me get a little information. I said, who's the attorney who sent this to you? So he told me, and of course I knew the attorney. And I said, okay, was there any explanation as to why the attorney couldn't get a decent settlement? And the doctor said no. And I said, well, you know, I usually try to approach these things nicely. And so I said, what I would do is I would call the attorney and I'd say, look, I just talked with Autumn. I understand she knows you, and she had some nice things to say about you. And she suggested that I just call and get an explanation as to why such a small portion of my bill is being paid. And so the attorney explained all sorts of things about the case. And then the doctor just simply said, you know, I'm afraid that my business director here is going to ask me to send this account to collection, and I'd really hate to do this to that patient. And before he got off the phone, the attorney had agreed to pay the bill in full and had rescinded the whole thing. And so that was clearly a situation where the attorney was trying to see how much the chiropractor knew about the process. I think that what a lot of attorneys assume is that if they send a letter telling the chiropractor that this is all they're going to get paid and that's what the statute says, that the doctor is just going to simply forget about the remaining balance. When I talk with doctors about combating a balance request, I always say, make sure that the attorney understands that you know you have a right to continue pursuing the remainder of the balance. And in your conversation with the attorney, if you're not real convinced that they're going to convey that to their patient, you have the right to send the patient a letter. So you can send a letter to both the attorney and the patient. Dear attorney, thank you for talking with me today. I understand you want me to cut my balance by 50%. That's not something that I think I can agree to at this point, and I would really hate to have to pursue the rest of my bill through a collection action or otherwise. And then what that does is it lets the patient know, like, hey, just because there's this 25% lien statute, that does not mean that this debt is going to be suddenly lifted as a burden from your back. So once you kind of understand the ins and outs of the statute, the other things I would say the other steps I would say that you should take in facing a reduction request are simply listen. Ask more questions than you make statements when you call the attorney. Get a good feel for what the facts are. Ask them to disclose to you how the numbers work. In other words, if they're saying, oh geez, unless you cut by 20%, the client nets nothing, say, may I see the numbers? Negotiate rationally. You know, if you find out that late in the case the attorney discovered that the patient had had 3 spinal injections in the week before the collision, lied in the deposition about that, and then claimed all of the same exact injuries after the collision, if you find that out, then be rational about what that means for you. Because you can always force a case to trial. You certainly have the right to do that. But you don't want to do it just for the sake of not taking a reduction. So in other words, if you're pretty certain that a verdict is going to be less money to the clinic than working on the claim with a reduction, then that's not really a good business decision. And that's a tough pill to swallow because I tend to be pretty emotional and I get riled up about things myself. But at the end of the day, I always advise people, make a good business decision. Don't make an emotional decision, make a business decision. And then the final thing I'd suggest is if you're faced with a reduction and you just really can't tell if you can trust the attorney on the other end of the line, then call an attorney you do trust, because I get those calls all the time. And I just don't know any of us in our community who aren't willing to help out a provider in terms of managing their way through a reduction request. And so if you call me or call another attorney you trust and you do the same thing that my friend did and you say, hey, here's the story, I just got a small amount, a small portion of my balance, and they said that's all I'm owed, then usually that attorney can give you some guidance and help you out. So that is it for my conversation tonight. I really appreciate all of your time, and I think David's going to open things up for questions.